we are done with the FIR part, and now comes the interesting, and I would say where the major changes has been made is in the investigation chapter. Before jumping onto the investigation, I would also like to tell you that what can happen in cases of non-cognizable offenses. As I told you that police can only register FIRs, that means they can only investigate cognizable offenses. What happens in non-cognizable offenses is that if someone goes to the police and says that so and so offense has taken place, but the concerned police official finds that no cognizable offense is made out, then he will make an entry in his record about that and refer the person to the concerned magistrate. Now, what the change has been done is that a time limit has been added that in every 15 days, the police has to forward the daily diary report to the magistrate. So basically, the purpose of this is that the police does not sit on the complaints. And I believe all of you know that investigation immediately starts with registration of FIR until the charge sheet is filed or the challan is filed. Everything what is done by the police legally, because police do a lot of illegal things as well, so that everything is investigation, rightly defined here, that gathering evidence, questioning witnesses, and analyzing information, and ultimately the investigating official gives his finding as well. So everything in that is that like culminates into investigation. Now, what are the changes in the investigation chapter? Now, I'll not strictly follow this PowerPoint slide. This says that forensic thing has been introduced. Yes, mandatory collection of forensic evidence. I'll cover this later, or I'll just follow this as well for your convenience. So, what has been done that where the offense is punishable with 7 years or more imprisonment, it has been made mandatory that the forensic expert should visit the crime scene. This is one thing. The second thing is that when the forensic expert visits the crime scene, the whole process has to be videographed, preferably through a mobile phone. As you could see that there is a 5-year implementation period, so states have been given some time to like arrange for the facilities, and the states can also take assistance of forward states, such as this is likely to happen earlier in states like Delhi or in Maharashtra, which are technologically and in other words advanced as compared to district like Jharkhand or state like Jharkhand. So I'm not sure that how practical this provision is, but I hope that this brings some changes, and this could see this provision goes both ways. It can help into conviction of where there is a rightful prosecution. Also it can help in acquittal of people wrongly indulged into the cases, those who have been innocently trapped into cases. So this has consequences both way. It can bring rightful conviction, also it can bring rightful acquittal as well. Though I can't say that this provision cannot be misused, this can also be misused. But I believe that this was necessary. This has been brought with a good intention. So this is what, can we move to the next slide? So this is what done in section 120. Yes, I guess. No, sorry, section is something else. All right. 176 clause 3, right? Yes, this is the next slide. So, as far as section 172, though this section does not deal with the investigation chapter, but I suggested to the Lawctagon team that we should include this in the lecture, because this is a new introduction in the BNSS and it is very necessary for lawyers to have knowledge about this. I personally believe that this is a very dangerous provision, and this can very easily be misused by the police, and it has a very vague words used in it, because what it says is that if someone refuses to follow the lawful directions of the police, now the words that are used is that any person resisting, refusing, ignoring, or disregarding. So these are very vague terms. resisting, refusing, ignoring, disregarding. So this gives a very wide power to the police official to arrest someone. So I believe that I don't know the intentions of the legislature behind having this provision, but still it's there, and it's necessary for all of us to have knowledge about this. Moving forward, now the FIR has been registered. Now, what is the further process? There are two, three key changes in it. Going by the bare language, once the FIR is registered, the police official would, the officer in charge of the police station would start the investigation. Now, what is the change here is that one proviso has been added that the superintendent of police, if he feels that the offense is grave and serious, he can ask the deputy superintendent to investigate the case. Earlier, it was not there. Moving forward, what are the further changes? Is that one, as I already told you about the judicial remedy to get the FIR registered, that the complaint, or sorry, the application to the magistrate has to be accompanied by an affidavit. So it is provided in this section 175 clause 3. Now, very interesting, and all of you must note the subsection 4 in this section 175. This is the first time that the accused has been given an opportunity to be heard even before the criminal process has been set in motion. See, we have IPC from 1860, we have the old CRPC from 1898, the new CRPC from 1973, and now this BNSS. So, in the history of criminal law, or for over 150 years, there was no such concept. Now, what is there in the subsection 4 of the section 175 of the new BNSS is that when the complaint is against a public servant and the complaint relates to what he has done during the discharge of his public duties. Let me clarify that the word used is complaint. It is not an application. The word used is complaint. The private complaint that is moved to magistrates, like in cases of defamation and so on. So even if a complaint is given to the magistrate, now the magistrate has two powers. Either he can take the preliminary evidence, or if he feels, he can order an investigation. Now in both the scenario, that is if he wants to order an investigation, or in case he wants to summon the accused, he has to do two things. First, he has to call for a report from the superior police officer about the facts and circumstances of the case. And secondly, and interestingly, the accused has to be given a right to be heard before doing anything, even before registration of FIR or even before summoning the accused. So this is a very interesting change in the law. I believe it's a good change because there is a tendency in government offices, like one government official might have some malafide intention to get the other uh, official trapped. So I believe this is a good introduction in the law that the government official would be given an opportunity to be heard before the order of investigation or before the summoning. Yes. So this is what is there in section 175. Moving forward, section 176. There is not much change in section 176. The only change is that the statement of the victim, basically of the victim of sexual offenses or of like acid attack victims, the statement of the victim can be recorded through audiovisual means, preferably through mobile phones. This is the one key change which is there in section 176, other than the thing we already discussed, that is the mandatory forensic investigation, that is also there in section 170. So though I would elaborate it bit further. The heading is of procedure for investigation. See, whenever the police official receives an information about commission of any offense, he has three options. The first option is that he can investigate it himself. Second option is that he can depute some subordinate. Third option is that he could refuse to investigate if he is of the opinion that no cognizable offense is made out. So one more change that is there in this section is that uh, one more change is that when the police official is of the opinion that no cognizable offense is made out, he has to forward the daily diary report in 15 days to the magistrate. So this again, like one section we already discussed about non-cognizable offenses, like there also he has to forward daily diary report in 15 days. So one similar provision is there in 176 also. For your practical knowledge, I would like to tell you that how actually this section works. Generally, what is done is that when the FIR is lodged, the police, after the FIR, gives a small note at the foot that who is appointed as the investigating officer and what is the immediate step has been taken by the police. So ultimately, the copy of the FIR itself is forwarded to the magistrate. So this is the practical aspect of section 176, that the police generally forwards the FIR itself to the magistrate. Forensic thing we have already dealt with. As far as section 178 is concerned, this is purely clear and theoretical. This is not something I need to give much elaboration on. Once the 176 report is forwarded to the police. See, I told you there are two things. Either he will register the FIR or he will not register the FIR. If he will register the FIR, practically they do the investigation. It is not the case that if FIR registered, then police will sit on it. It will do something. 178 is of importance when the investigation is not done, the FIR is not conducted. So there the magistrate has the power to direct investigation, though distinguishing it from the earlier provision where you can approach to the magistrate to get the FIR registered. It is a case where suppose complaint is given to the, sorry, the application is given to the police, but no FIR is registered, then as within 15 days it will be forwarded to the magistrate, and then the magistrate may order for investigation or can make inquiry through himself or through some subordinate judicial officer. So this has a limited purpose. Basically my focus is on telling you about the new changes in the law rather than merely like telling you about what is there in the theoretical part. Now section 179, as I could see on the screen, is section 185. I think this deals with search, so I'll come on this later. Or 185 deals with search and seizure. Now once the FIR is lodged, there might be, and mostly there are circumstances which requires that police should go to the crime scene or to whatever place the circumstances demand, and to like seize the relevant material for the proper investigation and conviction of the accused. Now what is the change is that the whole process of search has to be videographed, preferably through a mobile phone. Now this is the one key change, and I believe that this is a very big change that could like totally change the way the criminal trials are conducted. Because you see, the even a judge is also a human, and when you see something through your eyes through the way of a video, it totally changes your perception. So I believe once we like get into 5 6 months after this implementation of this law, this would have a huge impact, because once you could see everything with eyes, accordingly you would form your opinion. So this is a very good change, and I believe that this is a change, something which is brought with time, with technology, and it's a good thing that the legislature wants to keep pace with the time. Now there are few other things like section 179, which is of power of police to call witnesses. There is one change in this section, like if police, the investigating official wants to call someone to which he believes have knowledge about the case, he has to call him by sending a written something in written. But the change is that earlier a male person over the age of 65 years cannot be compelled to come to the police station. Now this age has been reduced to 60 years. And now there are some other categories also, like of female mentally physically disabled person or with acute persons with acute illness. They cannot be compelled to come to the police station. Though one clarification has been added in the new law that they cannot be compelled, but if they wish to come with their own will, they can surely come. Next section is section 180, that is of examination of witnesses by police. This section has stayed as it was in the old law. That was section, I believe, 161. So I'll take this section, two sections together, that is 180 and 181. So once the police calls someone to testify before it, firstly, those statements cannot be signed by the witness. Those cannot be used as evidence. The only purpose of those statements is to contradict the witness during the trial. No other purpose. It itself has no evidentiary value. Plus, these statements can also be recorded through audiovisual means, and it was there in the old law as well. It is not that it is in the new law. Now, one more important change, that is section 183, that is of confession and statements, which was earlier one section 174. One change, as I already told you, that in case of victim of sexual offenses, the statement should preferably be recorded by the women magistrate. So it is there in this section, not in section 173. Now, one or two more changes in this section is that where the offense is having punishment of 10 years or more, there the discretion of the magistrate has been taken away to refuse or to allow the recording of 164 statements. This is a very important thing. See, this could very well easily be misused, but at the same time, the intention behind is that to ensure more convictions in heinous offenses. So, as far as section 180, general things about this section is that before recording any confession, the magistrate has to inform the accused that he is not bound to make that confession, and the magistrate is supposed to inform the consequences to the accused. So, this is the general thing. Is that the recording of statement of sexual offense victim, it should preferably be by a women magistrate. And secondly, that in cases of offenses having 10 years or more imprisonment, the discretion of the magistrate has been taken away, and if the police brings any witness to the magistrate, in those cases the statement has to be compulsorily recorded in under section 183. Now, what is the difference between giving a statement to police on as compared to giving statement to the magistrate is that the former one has no evidentiary value, whereas this one is on oath, and this holds a great evidentiary value. Even in various cases, it can substitute the examination in chief as well. Like in this section, if you see for physically or mentally disabled persons and some other categories also, uh, 164 or 183 statements can substitute the examination in chief statements. Now, search by police officer, we have already dealt with it. One more thing is that if search is to be made outside the jurisdiction of a police station, then he should request the officer in charge of the concerned area to do the search for him. In case of emergency, he can like do the search himself as well, even outside his jurisdiction. Now, comes section 187. I believe that this is the most controversial change, and what why we have seen that the opposition parties, they have been crying about it. And like they, and in fact, to be very honest, when I have not read the provision, I was also under the impression that the police custody period has been increased to 60 or 90 days. So there was lot of confusion and there were lot of rumors about the change in section 187. But what is the change? The change is that the total period of police custody has been kept the same. Earlier also it was 15 days, now also it is 15 days. But what is the change is that earlier, if the person, if he is sent to judicial custody, he cannot be, the police cannot seek his custody again. But now the police can again seek the custody. Though there is some time limit, where the time limit for presentation of charge sheet is 60 days. In those cases, only in the first 40 days, and where the time limit for charge sheet is 90 days, in those cases, in the first 60 days, the police can seek the custody as many times as it wants. Though naturally, it is not that the police would simply go to the magistrate and the remand would be given. It would depend. The magistrate has to see whether or not there is actually any need for police remand or not. Sharing my own experience, I had discussion with a few other advocates as well. So there are different opinions on it. Like there are some advocates having the opinion that generally the police does not will not seek their remand again. What is there to be done is generally done in the initial remand period. But there is one opinion that police can misuse this provision and this would delay the uh, like if the accused applies for bail, the police can to in order to oppose it can ask for a police remand. So there are different opinions in it. What will be the actual consequences? That would be that we will see in future. Section 188 does not need much elaboration. You could say now section 189, that release of accused when evidence is deficient. It is also simple provision. Practical application is that suppose an FIR is registered and police arrest someone, and after having some discussion with the accused, and even sometimes the police arrest persons in order to have protect itself from the judicial scouting as well, that they simply arrest someone and then release them on bail. So section 189 is simply for that. Practically it is not possible that the investigation is completed and that the accused is or is not on bail. Now section, I would take section 190 along with section 193. Now there are some key changes in section 193. 193 is when the investigation is complete, then the charge sheet has to be filed. Now when the charge sheet or the challan is filed, there have been some changes. That is, firstly, in case of electronic evidence, the police has to maintain or complete record that how that electronic evidence traveled to the record during that period where it was kept, in whose custody, from whose custody it was transferred to whose custody, like A to B, B to C. Like it has to track all the journey of the electronic evidence. Second change is that after the registration of FIR, within 90 days, the investigating official has to inform the informant about the stage of the investigation. So this is one more two key changes. Now coming back to section 190, a very necessary change. If you have heard about the judgment of Satinder Kumar Entil, it's a recent judgment of the Honorable Supreme Court. Now it has been clarified that when the challan or charge sheet is presented to the court, it is not necessary that the accused has to be present. There is a practice in many states that when the challan is presented, the accused is unnecessarily arrested. Even just 2 or 3 days back, a judicial magistrate in Gujarat, he has been held guilty by the Honorable Supreme Court for its contempt because the bail was already granted, but at the time of presentation of challan, the accused was again sent to police custody. The explanation given by the magistrate was that this was a general practice followed in Gujarat, but his explanation was not accepted by the Honorable Supreme Court, and he was held guilty for contempt. So this is a good introduction. It has been clarified that the physical presence of accused is not required at the time of physical presence, or to be more specific, his arrest is not required. So this is a good initiative to protect the liberty of the person, Article 21 of the Constitution. Other than this, I believe I have mostly covered the changes that has been done in the investigation part. I'll give you just a 1 minute idea about the section 194 to 196 that deals with killing of humans. So in case of suicide or death or like dowry deaths, it is necessary for the police to make an report which highlights the like the prima facie things, like if someone has been killed or someone has committed a suicide and the police officer receives the information, then when he goes on the spot he has to prepare an initial report. What is there in the initial report, like if we see any wounds, any bruises, any fractures on the body of the deceased, he has to like make a report about that in presence of few private persons. As let me clarify, I believe some of you might also be having an idea about this, that this is the section that provide for post-mortem. Post-mortem word as such is not used in the CRPC or the BNSS. It is there in this section 194 and 196, where the post-mortem is provided. As far as section 196 is concerned, it basically deals with three situations. One is of dowry death, second is of custodial deaths, that's death that take place in the custody of the police. So basically it deals with that. Now what is the difference between 194 and 196? The difference is that in offenses in categories under section 196, the inquiry has to be made by the judicial magistrate, whereas the section 194 that only requires that things must be done in supervision of the DM or the subdivisional magistrate or the authorized executive magistrate. So this is one key difference between 194 and 196. I missed one point, that was of supplementary investigation or supplementary charge sheet. Like you must have heard in cases of Arvind Kejriwal, Manish Sisodia, like police is again, ED is again and again and again filing supplementary charge sheet. Now in the new section corresponding to section 173 of the old law, that is 193 in the BNSS, there has been a check on the supplementary investigation. Now, once the trial starts, the investigation can only be done with the permission of the court, and that investigation has to be completed within 90 days. And that period can only be extended by the court if the judge feels that it is necessary to do so. So, this is a very crucial change. I don't know how I missed it. Now, you need to understand that the term trial, the trial would start only when the charges are framed, and when the charges are framed and the accused pleads not guilty to the charges and he pleads that, sir, I want a trial. After that stage, officially the trial is called to be started. There are few other provisions, but I believe those have been kept same in the new law as well, like medical examination of rape victim. It is same as earlier. Few other provisions, those have also been retained. One thing that I would like to tell you about section 173, or sorry, 193, no, that is 187, which was earlier 167, that is of default bail. There is no change. It is for only your information that as to what is default bail. Like in certain category of offenses, the police is supposed to complete the investigation within 60 days from the date of arrest of the individual, and in certain categories it is 90 days. So if someone is arrested and the investigation is not completed within 60 or 90 days as provided, so the accused becomes entitled for default bail, right? But default bail will only be granted when the accused applies for it. It is not that it will be granted automatically. Yes, so I believe this was my version of what the changes has been done in the BNSS as far as the FIR and investigation part is concerned. Though the discussion would go on, but we have time constraints here. So this was my general view on the changes in the law as far as FIR and investigation is concerned. So yes, Suraj, we can take the questions now.
Good evening, sir.
Good evening.
Sir, my question is that does the trial period depends on the discretion of the judge? Like to start a trial, should a judge give order, or it just starts for the discretion of the police officer?
No, see, once the police has submitted the challan or the charge sheet, further the police has no control over the as to how the trial would further progress. It is
Okay, sir.
totally the prerogative of the magistrate. And having sharing my own experiences, sometimes it takes many years for the trial to start. As I told you that under section 173 of the old law and 193 of the new law, where there has been a bar on the supplementary investigation,
Yes, sir.
there the definition of the word trial becomes very important.